104, Schneider versus Finland. Counsel, would you like any rebuttal time?
5 minutes, please, Your Honor.
Sure.
Good afternoon, Your Honor. Nicholas J. Damadeo, representing the appellant, State of Saul Schneider. If an estate planning attorney commits malpractice that results in avoidable estate taxes, the decedent has no claim while he is alive, and the second he dies, a claim accrues, but no one in the world has standing to bring it.
So what's the rule you advocate?
Well, two parts, Your Honor. First, as Your Honor knows, one of the points is that, in my brief, is that this is not a privity case, and that is because this cause of action accrued while he was alive. Saul Schneider, if he had known about this, could have sued his attorney at the time. There would have been at least nominal damages. And
Could he have got his fees back?
Well, that's nominal, but I think it's more than that.
Some lawyers' fees aren't nominal.
That's true. I certainly agree with that, Your Honor. However,
we didn't know what the tax liability would be at that time.
well, the point is no one knows, but we hire estate planning attorneys because they can make pretty good estimates, and that's why we have this whole area of the bar. Saul Schneider was put in a position when he transferred that policy of having an additional $500,000 liability payable by his estate. He would have had, if he went to another lawyer and knew about this or found out about this, he would have had to make plans for that other $500,000 to be available. Otherwise, his estate wouldn't have been able to pay it.
What about the Ackerman case where we say it's when the professional advice is given that that's what begins the accrual?
Well,
we've done that also in the Quadro cases, like
yes.
in McCoy. So this would be deviating from that rule.
I don't think it deviates because I cite Ackerman. I think both sides cited Ackerman for support of their position. But with respect to Ackerman, I believe that Ackerman stands for the principle that in tax advice cases, the malpractice accrues on the day the advice is given and not when the tax is assessed. Well, the day the advice was given was when the policy was transferred. Saul Schneider was alive on the day the advice was given, so he had a viable cause of action at his death, which his estate under the EPTL may bring. Privity doesn't even come into play. I think Ackerman
and you're within the statute of limitations.
Yes, this is a case where we are within the 3 years. Unfortunately, he passed away less than 3 years after he transferred.
Now, if we had another case and you're not within the statute of limitations, then that's the statute of repose, you're just out?
I would be
standing. I mean, in this particular case, the decedent died within a relatively short period of time from the transfer of the policy.
He did. I mentioned in my brief, and referencing Professor Fogel's article, that one of the problems that often arises in these cases is that the 3 years has already expired before anyone finds out about the malpractice. That's not the case here. If that were the case here, I would be arguing that there should be a discovery rule. I think that's only fair.
That's what some states have.
Many do. I don't believe we have it yet, but today is not the day for that discussion, although it certainly will come up.
So we don't really need to address the accrual issue here?
Well, you do have to address the accrual issue to the extent that it's the position of the respondent that no cause of action accrued during his lifetime. And, of course, the issue that they raise is, well, you're claiming lost or increased estate taxes. How could they have accrued while he was alive when they're not payable until he's dead? And I think that 1 second between life and death that I mentioned in my hypothetical at the very beginning emphasizes that that is just a ridiculous artificial argument. The whole reason for going to an estate tax attorney is to plan for that event and to minimize those taxes. And to say that he fails to accomplish it because of malpractice, but there's nobody alive who can sue him, it just cannot be the public policy of the state. It's so blatantly unfair.
And who assumes that responsibility, the personal representative or the beneficiaries of the estate?
The personal representative and only the personal representative. In this particular case, this is not a case of the disgruntled beneficiary. There are a lot of cases about, in the privity law, about the beneficiary who didn't get what he or she thought he should get, or the case where they were made to witness the will, thereby losing their bequest. You know, blatant malpractice issues like that, which unfortunately, because of the privity rule in New York, those people were out.
Mr.
That
Damadeo?
case is not here. Yes, Your Honor.
How old was the decedent when he died? What's in the record?
He was, I believe, in his mid-60s, early 70s. I'm not quite sure. I actually did not know him personally. So I really don't know for sure how old he was.
Does the record tell us why this policy was transferred in this manner?
The record is sparse because this was a motion to dismiss. Issue hasn't even been joined yet. There's been no discovery, which is why the complaint is as general as it is.
You said you don't rely on privity, but wouldn't this be closer to the doctrine that the relationship is so close as to approach privity, that the relationship of the decedent to the estate?
Well, I would say yes, but you don't have to go there. And I've read those cases about how close is the relationship so that we have it. But I think that sometimes that's a strain to find a remedy when we don't have to work that hard to do it.
So you don't like the Belt case?
I like the Belt case because the Belt case says Deeb versus Johnson is wrong. I think Deeb versus Johnson is a terrible decision. It makes that artificial distinction of the 1 second between your last breath and when the IRS is coming. And I think it's just wrong.
But you're not suggesting that we adopt the holding of that case?
Well, it's an alternative, but I think it's too restrictive, frankly. I'm much more in favor of a third-party beneficiary theory or Professor Fogel's clear and convincing evidence test.
That theory would rescue these unfortunate beneficiaries you were talking about earlier, the poor lady who lost her legacy because she witnessed the will.
It would, Your Honor. And again, it's a much broader solution to the particular problem presented by Schneider.
Is there any reason for us to address that in this case?
I would say no. Frankly, adopting Belt addresses the problem in this case, because Belt simply says that personal representative, not those disgruntled beneficiaries, that personal representative is the one who stands in the shoes of Mr. Schneider. He's just continuing that cause of action that Schneider had that accrued during his lifetime.
As I understand, you have two theories. One is that the cause of action existed before death.
Yes.
And the second is, even if it didn't exist before death, even if it was only the estate's cause of action, the estate is virtually in privity.
It is.
Which of those did Belt adopt? Did it adopt both of them?
Well, Belt is kind of a hybrid. I think Belt adopted that the estate is in privity, the way I read it. That's what I think Belt was saying. But I'm not so sure we have to go that far. Either way, the result is the same. But that is my second theory, is that if there's privity, if privity has to be in place, that New York strict privity rule needs to be modified at the very least. And I know the Court is aware that there are all kinds of commentators with all kinds of theories on what the rule should be. And I think Professor Fogel's article is interesting and enlightening because he talks about the three main theories and says none of them should be in existence. None of them work. And I agree with him. I think that we still haven't found that middle ground. And I'm here today to submit that it's time to find that middle ground.
There's quite a few different approaches around the country. Different
Absolutely.
groups of states have different approaches. So could you summarize again what you're proposing to us, you think, to resolve this case? The rule
Well,
would
my
be?
proposal to resolve this case, frankly, is the Belt decision, that this is a cause of action that accrued during the lifetime of the decedent, and the personal representative who stands in his shoes has the right to bring it. I think that the cases in New York that talk about how you can't do the end around and have the executor bring the action because it's really for the benefit of the beneficiaries, but they're not allowed to bring it because they're in privity, I don't think those cases, frankly, give justice to the judiciary, who certainly is capable of distinguishing between whether this is a claim for the estate or this is the claim of a particular disgruntled beneficiary. Clearly, in this case, this is an estate damage. It has nothing to do with the beneficiaries whatsoever. So the adoption of the rule that an executor or personal representative stands in the shoes and therefore may bring this action even though it involves estate taxes. And that's really why the lower courts dismissed this case, because the complaint alleges this large estate tax liability, and it doesn't sue for his legal fees that he could have made, but the fact is those damages were present if he had known about it. But this Court has never hesitated to find that causes of action accrue even when the damages are $1 or you don't know about it yet. So in this case, they've accrued. I don't have any doubt that if Saul Schneider found out about this during his lifetime and sued Mr. Finman 4 years later, Finman would be saying, well, statute of limitations, he should have sued when I gave him the bad advice. But today, because Schneider's dead, his argument is, well, he couldn't have sued when he found out about the bad advice. He had to wait till those estate taxes accrued, and by the way, he's dead and nobody can sue under privity. So it's a terrible rule. And I think that if you limit this decision to finding personal representative has the standing to sue, this case is resolved. But it doesn't address the much broader issue that the case raises, and that is the privity argument. And as I mentioned, Fogel has said that the California rule is too broad. The New York rule, which I think only 8 states have, is just way too harsh. And the middle rule of Florida just doesn't work because it relies only upon documents and doesn't deal with the much larger issue that we have here of estate planning. This is a huge industry. People are inundated with advertising about coming to estate planning seminars all the time. And the public has no idea that their attorneys are totally insulated from liability under New York law. And it's wrong. And that's why I think that this Court has to address the issue, whether it be narrowly in the estate planning context, that the personal representative has jurisdiction when it's solely an estate damage. And obviously, if the Court chooses to go beyond that, addressing the privity as a whole in estate planning cases, I think we need to move in the direction of either a third-party beneficiary or a clear and convincing evidence standard. And if the Court has no other questions, I will stand on my brief.
Okay, counsel. Thanks. Counsel?
May it please the Court, I'm Peter Misnalio, and I represent Mr. Finman. I think Judge Graffeo asked why was it transferred, and as counsel indicated, the record doesn't show. What they do say is that, because they don't know, they say, well, it was transferred either because Mr. Finman gave bad advice or because he failed to give good advice. So there's one of the reasons why
We have to assume, for present purposes, that he was at fault, don't we?
we have to, because we haven't dismissed it on that ground.
Suppose he had given bad income tax advice instead of giving bad estate tax advice, and then the man had died and the IRS had gone to collect the money after death. There'd be no doubt about the estate's right to claim malpractice, would there?
That's correct, Your Honor.
So why should it make a difference that the error was an estate tax?
Because the whole concept of tort, and whether it's negligent misrepresentation or malpractice, is that the party who was the victim of the tort was injured. You know, if we're going to all of a sudden say that, well, we can count injuries that occur a moment after he died, or when the IRS, I guess in this case, imposes an estate tax liability, we've totally changed the whole concept of
If Mr. Finman,
tort.
we don't know when Mr. Schneider died, but let's assume he died before he paid the bill. If Mr. Finman sent the bill to the estate, would they say, no privity, we're not paying it, and would you then have no cause of action?
I believe this Court in Kronos drew a distinction between breach of contract and a simple and tort. And breach of contract, you have you can infer nominal damages, and I think we would be liable if the estate asked for the fees. If we gave bad advice and it turned out that he was damaged, he had to get another lawyer in to straighten it out, we would probably owe him the fees.
So there's sufficient privity with the estate for purposes of Mr. Finman getting paid his fee if it hadn't been paid prior to Mr. Schneider's death?
And that's because Mr. Schneider suffered an injury when
that's my point.
Alive.
Let's assume he didn't. You know, Finman says, you owe me $10,000 for this advice. I realized when you walked out of my office you get hit by a car and you're dead, but the fact of the matter is that now your estate owes me $10,000. They say we're not paying it because the advice was bad, and you're saying there's no counterclaim because there's no privity with Mr. Finman over the advice he gave, even though the estate must pay the bill for the advice that was given.
If Your Honor's question is whether if Mr. Schneider received bad advice and he was charged $10,000 for that advice, then he was injured during his lifetime. But if that advice ended up in somehow generating a tax liability that accrued to his estate.
Well, I think Judge Pickett's question is, if he gets bad advice and he hasn't paid the bill yet, and he dies, can his estate assert the malpractice as a defense to the $10,000 claim?
I think Mr. Schneider is entitled to receive good legal advice from.
That's a yes. The
from his
estate
attorney.
can assert the defense.
I would think so.
Why the defense and not the counterclaim?
I don't think that there's really a difference between the defense and the counterclaim.
Well, but you're saying that the estate can't sue the lawyer for malpractice.
The estate can't sue the lawyer for malpractice when the the injury that the estate suffered accrued after the death. If the injury that the estate suffered, or that the late Mr. Schneider suffered, was as a result of...
But why can't ordinarily you can add new items of damage for the same tort. I mean, if there was some kind of property damage that his house had burned down, or his house was in decay and it decayed partly before his death and partly after his death, the state could sue for both items of damage, couldn't it?
If you start out with injuries resulting from a tort and that somehow they get worse, the broken leg all of a sudden dies in a malpractice action.
Mm-hmm. I can't think of an example where the plaintiff is dead, but even a whole new kind of injury still relates back to the date of the original tort, doesn't it?
But when you not the kind of injury that we have here, which is all of a sudden an estate tax liability accruing. Because as we know, if two things could have happened in the meantime. One is that Mr. Schneider could have changed the direction of the insurance policy, sent it back to one of his partnerships, and the other is he would have survived another 2 years, or whatever the period of time was.
Well, let's take the case where an architect builds me a house and does a bad job, and in my lifetime the floor falls in, and then after my death the roof falls in. Those are both items of damages in the same lawsuit, aren't they?
Yes, they are. And that's because you, the owner of the house, received bad architectural plans, and you were damaged at that point because you had a house that was susceptible of having two things happen to it, one of which happened during your lifetime.
And can my estate sue for the damage to the roof?
Yes, because
So why doesn't the Ackerman rule on accrual apply here?
Well, the Ackerman rule on accrual had to do with an income tax. At that point, if I remember correctly,
That's the difference? I mean, if Mr. Finman was an accountant and suggested the transfer of these insurance policies, we wouldn't apply the Ackerman rule?
The Ackerman rule...
It's at the time the advice is dispensed to the client?
The Ackerman rule is when the advice is dismissed to the client, because at that particular point in time, the client is injured. The client has a income tax liability. They've taken deductions to which they were not entitled, and now they not only owe income tax, but they probably owe interest and penalties, as opposed to what happened to Mr. Schneider, which is nothing happened to him.
Mr. Schneider wasn't injured at the time he got this advice? I mean, in the context of a 3211 motion to dismiss.
Not to the extent of having a loss, which the court in Kronos and, of course, a whole slew of other cases has said is necessary to establish tort liability.
So it depends on the type of tax liability?
The question is he in a position to bring an action? Was Mr. Schneider in the position when he got this particular
if he had gone to another attorney 6 months later, perhaps that attorney would have said to him, boy, you've gotten bad legal advice here. You've created this potential for fairly substantial tax liability for your estate, which is the opposite of what you went and sought legal counsel for.
That's correct.
Wouldn't he have had an action at that juncture?
He wouldn't have had an action to recover the estate tax liability that accrued 6 months later after he died. He might have
been less damages, but
he would have had an action to get back the attorney's fees that he spent for Mr. Finman, but he wouldn't have had an action because he hadn't suffered any loss at that particular point in time. Unlike in the Curbine case and Ackerman, where we're dealing with income taxes, where there was a liability established at the moment the bad advice was given. And correctly, you can't extend that out to when the IRS assesses. It's when the tort occurs and when the plaintiff is in a position to bring a lawsuit. And Mr. Schneider was not in a position to bring any lawsuit against Mr. Finman during his lifetime because nothing had happened. And he could have changed his direction and hopefully would have lived long enough to have this all would have become moot. Obviously, to deal with the other issue, which is whether there should be a change in the law, I think this Court has worked hard and carefully over the last 80 years, I guess, to deal with the issue of the negligent misrepresentation and to expand to some limited extent the privity issue It's spoken on whether it wants to go further than that and to develop or go into foreseeability as a standard, and has indicated in a number of decisions, most recently in 2005, that it really didn't want to do that. It would just open up.
In the limited case of where you're dealing with a living individual and his estate who can't exist at the same time, what's the policy reason not to treat them as one for these purposes?
Not to treat the individual and the estate as one?
Yeah, the same. Yeah, treat them as being in privity or as though they were the same person.
Because the individual, you have to treat them differently, I would suggest, Judge Smith. One is the individual had no cause of action when he was alive, having to do with the bad advice that he gave, other than possibly to get his fees back. The estate does have a...
I mean, I understand the theory, or at least I think maybe I do, but is there a policy reason underlying it? Will the world be a worse place if we treat an estate as being in privity with the deceased?
Because you're going to be changing, significant change in the law of torts. Because you're going to have, first of all, the estate is not a person, as we all know. The estate is an amalgamation of the property of the decedent at the time. The only person, state can't bring a lawsuit. Only the personal representative can bring the lawsuit. So you're going to be establishing privity where none exists. Obviously, the Court of Appeals can establish privity, but it doesn't. It's going to be a significant change in the law, and I submit that...
well, except in our recent case in Heslin against the County of Greene, which I know is a very different case from this, but we said the personal representative stands in the place and stead of the decedent in terms of a tort claim that belonged to the decedent.
Well, there's no question that that's the case, and that's what the survivor statute provides, that if there were a tort claim that Mr. Schneider had when he was alive, absent statute of limitations, which is not a problem in this case, the personal representative could bring an action.
So it's because the nature of the damages is different?
It's because of the fact that...
Is that what you're focusing on?
Yes. There was no estate tax damage, the kind of damage that they're interested in recovering in this case.
So what case best supports your position?
Well, obviously the decisions of the Supreme Court and the appellate division, but the Cattell case, which is a surrogates court case, and the whole slew of the appellate division cases dealing with the Deeb case, which is almost right in point, which is an appellate division, I believe, third department case. They all take the position, as we're arguing here, and as the appellate division found in this case, that this kind of estate tax liability is not something that the decedent could have brought, and therefore his estate or the personal representative of his estate cannot bring the cause of action.
Mr. Damadeo makes the point that there's a lot more of this estate planning stuff going on, that there's advertising for it, et cetera. Whether that's true or not, do you have a thought on the idea that lawyers can give advice knowing that there's no consequence? Because if they say to people, put all your money in trust, or take all of your cash and buy life insurance and do things that ultimately hurt them, that because the advice is given to the person when they're alive and the estate can't sue when they're dead, there's really no liability for giving what could be very bad advice to an awful lot of people. Do you have any thought on that?
Sure. Giving bad advice is something that lawyers are sworn to avoid, and it's not only malpractice liability that enforces that obligation, but it's also the disciplinary rules that we're all subject to. We're supposed to practice law according to the highest standards.
Well, there's also, and I suppose there's also a little economic. Yeah, if you're known as giving lousy advice, your business falls off.
And that's even a more practical one. But I'm just trying to be a little more technical. But that's part of it. And I think on the other side of it, and these are some of the arguments that the commentators make, is that to all of a sudden make the lawyer, when he's trying to represent his client in the best manner that he or she can, to start thinking about all the possibilities of concerns about beneficiaries, and that's really what this is. This is a beneficiary complaint. That, and that all those concerns all of a sudden imposes another client on that lawyer that he or she never, never retained him, and that person's interests all of a sudden become important. And that's a big concern that we have once you broaden this and start making these beneficiaries all of a sudden somebody critiques.
How does this raise that issue? How does it become a beneficiary issue?
Well,
I guess everybody gets more if the estate's larger, but...
As an example, just to take, in this case, maybe there was a reason why Mr. Schneider, brought this policy back into his own name. Obviously, counsel doesn't know whether it was my client who told him or didn't tell him the right thing, but maybe there was a reason.
It had nothing to do with tax liability? Is that what you're suggesting? There may have been some other reason?
There may have been some other reason. There may have been all kinds of business reasons. Maybe he was somehow concerned about his, and all I know is that it's a partnership, so I'm just guessing here, but maybe he was concerned about taking care of his partners and not necessarily about taking care of the beneficiaries of his estate. If all of a sudden the lawyer now has to be deposed about his conversations with his client, which were possibly intended to be confidential, we just open up a Pandora's box as far as the estate having that kind of a claim with respect to damages that occurred after the
But the estate has one personal representative, whether it's the executor or administrator. It has one personal representative. And an estate could, beneficiaries of an estate could be one person, or it could be a charity, or it could be 20 people. So I don't think that a rule, as counsel proposes, would create these conflicts. Certainly, he's not going to be thinking about what happens to all 20 possible beneficiaries of his estate.
But the typical, Judge Saparic, the typical estate is everything goes to your wife or your children. And for some reason...
Assuming he's married, assuming he has children.
Assuming he's married and assuming he has children. I'm just an assumption here. I know what the answer is, but it's not in the record. But, there may be reasons why he did what he did. And now all of a
That
sudden,
goes to the malpractice, whether there was malpractice or not, doesn't it?
I'm just talking about the public policy that I was asked about in opening up these, a lawyer to depositions about why things were did, what conversations did you have with Dad or with the decedent, and he has to tell them they were intended to be private. I realize it may protect him against some liability, but I think there.
But if this were income tax instead of estate tax, you could have the same kind of inquiry.
You would, but I think the rules that this court has set up with respect to, and the legislature as well, because they passed the survivor statute, is that that's fair game. But when we're dealing with liabilities that accrued after the death, there's no privity. And this court has changed the privity rule to some extent in certain circumstances, and this is no more than just a negligent misrepresentation case. And clearly there's no reliance here. And the Credit Alliance standards,
Could that be said of any legal malpractice case? It's at least in any legal malpractice case based on bad advice is a negligent misrepresentation case?
I think so. I think a bad advice case is not the ones where the lawyer misdrafted a will and all that, but bad advice cases are negligent misrepresentation cases. So I think the Credit Alliance standards apply here, and the narrow circumstance that this court drew with respect to when it can be overcome is very limited, and obviously involves reliance and knowledge on the part of the court or on the part of the testator and the lawyer as to who would be relying. So if there are any other further questions, I'm
Counsel.
finished. Thank you.
Counselor Rebuttal.
I'd be pleased to answer any questions, otherwise I'll waive my rebuttal time.
I do have one. As your opponent just indicated, are we opening a new cause of action separate, and cause of action number 2 after undue influence, that the lawyer was guilty of malpractice because Dad couldn't possibly have drawn a will that would have left me out?
No, and that's not the case before us today.
Why aren't we doing that? Why?
Well, first, this is not a will drafting case. Second, this is not a case of a disgruntled beneficiary crying that he or she was left out of the will and didn't get as much as Dad promised them.
You're saying that there's a difference in an injury to the estate and an injury to a beneficiary?
There is, and if we're going to, it would take a much broader abolition of the privity rule to encompass the class of beneficiaries than it would to encompass the particular
He's
plaintiff.
saying, in essence, it's the beneficiary. Isn't that his argument?
Well, that has to be his argument, but it's just not true. I mean, I think that's an artificial distinction that the court, any court can differentiate between when it benefits the estate, when it benefits the beneficiaries. Obviously, Your Honor is correct. Anything that increases or decreases the size of the estate indirectly benefits the beneficiaries, but that's not enough to exclude everyone from being or having standing to sue. The executor can wear multiple hats. And in fact, usually that's the case when family members are involved, and that's the case in this case. His daughters are the co-executors.
Is the statute of limitations 3 years?
It's 3 years, and it's not an issue here. He died within 3 years.
Right. I'm just wondering how far back, if we were to change the rule, we're extending it.
I don't know, Your Honor. That would be a different day and a different case. But I don't think you're opening any Pandora's box by reversing here.
Okay.
Thank you very much.
Thanks, counsel.